presented by the Pennsylvania Department of Education, Division of Food and Nutrition in collaboration with Project PA. I'm Elaine McDonald, coordinator of Project PA, and I will moderate today's webinar. Before we get started, just a few bits of housekeeping. We'll take questions following today's presentation. At any time during the presentation, you can type your questions into the chat box and we'll collect them and address them to the presenters after the presentation. There are a couple of items in the file share box in the lower left-hand corner of the screen. Actually, both documents are the slides for today's webinar. The one that says 10 pages is the slides in handout format, so 3 slides per page. The 29-page document is 1 slide per page. At the end of the webinar, a continuing education certificate will be available to download from the file share box. Finally, we are recording today's webinar and we will post the audio from the webinar along with the presentation slides and the Q&A on the Project PA website. Okay, I will now turn the webinar over to our presenters, Jenny Edmondson and Kathleen Hiltwine, Public Health Nutrition Consultants at the Division of Food and Nutrition.
Good morning. Thanks, Elaine. Welcome, everyone, to PDE's training on USDA's updated guidance on modifications to accommodate disabilities in the school meal programs. Before we get started this morning, we at the Division of Food and Nutrition just would like to say that we recognize that this updated guidance from USDA represents a shift in policy regarding the way school nutrition program operators, school food authorities, and local education agencies are to view and accommodate most physical and mental impairments when providing school meals. We expect that you're going to have a number of questions on how this will impact your operation and procedures. And we are going to answer your questions to the best of our abilities today. For questions that we are unable to answer today, we will seek guidance from USDA and we'll include them in a Q&A memo that we'll release later this summer so that you have the information you need heading into the 17-18 school year. In addition, we will provide our contact information, of course, at the end of the presentation so that you're able to send any questions or scenarios that you might think of later on to us. Today's objectives include a brief review of the laws, regulations, and other legal authorities that provide the framework for civil rights protections in federal programs, including the school nutrition programs. Specifically, we will focus on the laws that prohibit discrimination based on disability, including an explanation of how the Americans with Disabilities Act, Amendments Act of 2008, expanded and clarified the meaning of disability. USDA released a new policy memo in September 2016 and also a Q&A memo in April of 2017 that updated the guidance on accommodating disabilities in school meals. We will review the new guidance and how it pertains to your duty as SMP sponsors to accommodate children with disabilities to ensure they have an equal opportunity to participate in school meals. As you'll see on this and the next slide, there are a variety of civil rights laws, regulations, and executive orders that apply to federal programs, in addition to other resources that provide relevant guidance on civil rights. We're not going to be discussing these in detail, and these slides are not an exhaustive list, but we're providing them here as a reference to you. For purposes of today's webinar, we are primarily talking about Section 504 of the Rehabilitation Act of 1973 and the Americans with Disabilities Act of 1990, or ADA, which was modified substantially by the ADA Amendments Act signed by George Bush in 2008. In addition, you will find most of the civil rights regulations pertaining to school meal programs in Chapter 7 of the Code of Federal Regulations, Part 15. The section of the CFR that specifically addresses disabilities is 7 CFR Part 15B, titled Non-Discrimination on the Basis of Handicap in Programs or Activities Receiving Federal Financial Assistance. We placed an electronic link to 7 CFR Part 15B on PAIRS download forms in the Feeding Students with Disabilities and Special Dietary Needs section, and it's located at PDE-SNP-043. Disability law is held up by two key statutes, Section 504 and the ADA. These both prohibit discrimination based on disability. There are also implementing regulations and policy guidance that provide further direction, some of which are included on the previous slides. In addition to preventing or prohibiting discrimination based on stereotypes of people with disabilities, both Section 504 and the ADA require schools to provide reasonable modifications to ensure equal access and opportunity to participate in and benefit from federal programs. The key to this is understanding and accepting that the duty to provide modifications is sometimes nebulous. In fact, each situation is unique and requires a case-by-case analysis. Today, we're going to provide some guidance to help you make those decisions, and we want to stress that the focus for schools should be on what can be done to ensure equal opportunity to participate in or benefit from the school nutrition program. The ADA Amendments Act of 2008 expanded and clarified that Congress intends the term disability to be broad and inclusive, and it did not change the expectation to provide a reasonable modification. The ADA Amendments Act placed the emphasis on the duty of schools to provide the reasonable accommodation. Additionally, the disabled person does not carry a high burden of proving that he or she has a disability. Because the ADA Amendments Act simplified the question of whether a child has a disability, for purposes of making accommodations for school meals, schools do not need to do extensive analysis or weigh medical evidence against the legal standard to determine whether a particular impairment is severe enough to qualify as a disability. After the passage of the ADA Amendments Act, most physical and mental impairments will constitute a disability. The legal definition of disability has not changed. It remains a three-pronged definition of potentially three different avenues for establishing that a person has a disability. The first one is an actual physical or mental condition that impairs and substantially limits one or more major life activities. It's also possible under the definition to qualify for civil rights protection if a person has a record of having such an impairment in the past or is simply regarded as having such an impairment. The second two definitions generally play a role in civil rights claims based on stereotyping and negative views about people. However, today we're talking about modifications to school meals, which is typically tied to the first definition, a person with a physical or mental impairment that substantially limits one or more major life activities. The ADA Amendments Act revised the test for what constitutes a substantial limit and made it very clear that this is a low threshold. We now know that a condition does not need to prevent or significantly or severely restrict a major life activity to qualify as a substantial limit. So questions about the severity of the disability are not as important or relevant to the discussion. Every situation is unique and requires an individualized assessment. The assessment must be made without considering the effects of measures that might mitigate or improve the condition. An example would be a person who wears a hearing aid for a hearing impairment. When deciding whether that person is disabled, the assessment would consider the person's hearing without the hearing aid. The revised definition may include impairments that are episodic or in remission if the impairments would substantially limit a major life activity when they're active. This expanded provides some direction about the intent of the ADA. The intent is to make the threshold question of whether a person has a disability a very simple and low standard for people to meet, and to shift the focus of the analysis to what is required to give them equal access. For someone who might have a disability that's in remission, for example, there's no need to argue about whether that person has a disability. Instead, you would talk about what accommodations are necessary while the person is in remission, which might be much less or even none at all compared to when their condition is active. Part of the definition of disability is that the condition substantially limits a major life activity. The ADA makes it clear that major life activity is broad and inclusive. Seeing, hearing, walking, speaking, learning, reading, eating, and breathing are all recognized major life activities. The Act also adds a new category of major life activities. Major bodily functions also clearly constitute major life activities. According to the ADA, most physical and mental impairments will constitute a disability. This includes conditions that impair immune, digestive, neurological, and bowel functions, as well as many others that could require modifications to school meals. As sponsors of federal meal programs, your schools receive federal funds and are required by law to accommodate disabilities in school meals. It is important to remember that under Section 504, an organization that receives even $1 of federal money brings the entire scope of the operations within the jurisdiction of Section 504. This is true even when the modification requested is not related to the part of the operation that receives federal financial assistance. Section 504, the ADA, and federal regulations establish several different types of discrimination. There could be general discrimination because of a disability, including the denying of benefits or the opportunity to participate. Segregating individuals with disabilities, for example, requiring students to sit at a separate table, can sometimes constitute discrimination. And aiding or contracting with others who discriminate. By taking federal money as sponsors of the school meal programs, schools are accepting the duty to ensure that people they work with, and therefore pass those federal benefits on to, also are not discriminating based on disability. Another type of discrimination is failing to provide a reasonable accommodation, because when you accept federal money, you are required to ensure equal access to program benefits, which often include modifications or substitutions to the meal pattern or the meal service. The last two types of discrimination are important to know, but they're not addressed directly in the guidance we're providing today. It is considered discrimination when effective communication is not provided to persons with disabilities, such as individuals with hearing impairments or other conditions that would require special accommodation for effective communication. Finally, facilities are required to be accessible, such as for individuals with conditions affecting their mobility, which is an area that schools are generally very familiar with. On September 27, 2016, USDA issued updated guidance on modifications to accommodate disabilities in the school meal programs via a policy memo, and just a few weeks ago released a Q&A memo related to the new guidance. This guidance specifically covers the school meal programs, the National School Lunch Program, School Breakfast Program, Special Milk Program, and the Fresh Fruit and Vegetable Program. Both memos are available on PAIR's download forms in the Feeding Students with Disabilities and Special Dietary Needs section. For those of you who operate the Child and Adult Care Food Program or the Summer Food Service Program, USDA plans to release similar guidance for CACFP and SFSP sometime in the near future. Also, we want to note that this guidance only addresses modifications required to accommodate disabilities. Additional guidance on accommodating special dietary needs and preferences that are not related to a disability will be provided separately by USDA. Let's take a look at what USDA guidance tells us. First, it covers meal modifications. A reasonable modification is a change or alteration to a policy, practice, or procedure to provide a person with a disability the opportunity to participate or benefit from the services of the school meal programs, which are equal to those afforded any other student. An example of a reasonable modification to a school meal policy would be substituting a nutritionally equivalent soy beverage for a student who cannot consume fluid milk as a result of lactose intolerance. Another example of a reasonable modification would be changing a program practice, such as providing a student with diabetes a reimbursable meal outside of the normal meal service time based on that student's medical need to eat at regular intervals during the day. So how does the school determine what modification to provide? The regulation provides a standard that says schools must provide the aid, benefit, or service that is equally effective in affording equal opportunity to obtain the same results, to gain the same benefit, or to reach the same level of achievement as that provided to others. Essentially, this means equal opportunity, whatever would allow the child to equally participate and benefit from the program. In order to arrive at that modification, the school should discuss with the family what modification would work best for the child. Simply saying no is almost never appropriate. This means that school personnel should talk with family members to discuss the limitations and barriers that may exist, ways to overcome or eliminate those barriers, and what modifications are available that can allow equal access for the child. The focus of this discussion, however, should be on what modifications should be implemented that is effective and reasonable. It should be a cooperative process that allows the parties to reach an agreed upon modification. The focus should not be on whether the child has a disability, nor should it require extensive analysis. Instead, the central concern for schools should be how that child can be accommodated to meet his or her need and ensure the child can participate equally in the program. Because circumstances vary, even when a disability diagnosis may be the same as another student at the school, each situation should be treated on a case-by-case basis. The modification requested must be related to the disability or limitation at issue. For example, if a child has a vision impairment, they may need a modified version of the school cafeteria menu, but they would not be entitled to a special meal because that is not related to the child's vision impairment. Also, schools are not required to provide the specific modification requested, only one that is effective in providing the child equal opportunity to participate and benefit from the program. For example, if a family requests a brand name item, in most cases, a generic brand is sufficient unless the brand name item is medically necessary. This can be determined through the inclusive process with the parents or guardians. Even when the parents and the school don't agree, the modification should still be provided. The school should implement the modification that it believes is effective in order to comply with the law. It is almost never appropriate for a school to decline to provide an effective meal modification to accommodate a child's disability, provided that the modification request is related to the child's disabling condition. The exception would be a modification request that would fundamentally alter the nature of the program. The phrase fundamentally alter is not defined in law or regulations, but we do know that it is a rare circumstance that would require a significant change in how the program is run or the services or benefits provided. An example might be if a parent requests that the child be transported to a location off-site and the meal be served to the child there. This is a request that may fundamentally alter the nature of the school meal program, which is designed to provide meals during the school day on school property. If the school has concerns about a request, the school is responsible for working with the parent or guardian to develop an appropriate modification and is applicable suitable alternatives for the child. There are some key considerations we would like schools to keep in mind when making reasonable accommodations. First is cost. Schools should certainly consider cost when making decisions regarding modifications. Schools may consider all available resources. But when trying to decide between multiple options, a school may choose the most cost-effective option as long as the modification is effective at removing the barrier and ensuring the child has equal access to the school meal program benefits. We also encourage schools to consider the age of the child that they are accommodating. For instance, if an elementary school student needs a modification, that student may require more assistance or more supervision than a high school student who may be more adept at identifying foods they may consume or should avoid. It's important to keep the modification decisions exclusively based on the facts and information available and as they pertain to that specific child. Decision makers should avoid using personal experiences to arrive at modification decisions. One size does not fit all, so what may have worked for one student or one family member may not work for the situation at hand. The modification decision should be tailored to meet the individualized need of the disabled student. The modification does not need to mirror the menu item that is being substituted. Let's say that a school traditionally serves pizza on Fridays, but a student is allergic to dairy foods and cannot consume the pizza. The school is not required to provide a dairy-free pizza or any other form of pizza as a substitute. The school may choose a different item altogether and make that item available to the student as a reasonable accommodation. Lastly, the law does not require that lifestyle choices be accommodated. General health concerns, such as a parent's preference that a child eat a gluten-free diet because the parent believes it is healthier for the child, are not disabilities and do not require a modification. SFAs are encouraged to provide a variety of foods for children to select from in order to accommodate food preferences. Meal modifications for religious, ethnic, moral, or other reasons may be reimbursed, provided these meals adhere to the required meal patterns. I'm going to turn it over to Kathleen now, who's going to talk about food allergies.
All right. According to the Centers for Disease Control and Prevention, there are 8 foods or food categories that account for 90% of serious allergic reactions in the United States, which are listed on the slide. Schools are encouraged to develop standard procedures to address and accommodate these 8 common allergens, since you are likely to come across students who have these food allergies. As you know, a food allergy is an immune system reaction that occurs after ingestion of a certain food. An allergic reaction may impact one or more major bodily functions or other major life activity, such as digestion, respiration, immune response, skin rash, etc. Therefore, food allergies will generally be considered a disability under the expanded definition of a disability under the ADA Amendments Act. A food allergy does not need to be life-threatening or cause anaphylaxis in order to be considered a disability. Questions frequently come up regarding peanut allergies and whether it is recommended for schools to establish a peanut-free policy. It is not a USDA or PDE policy to require universal exclusions of a specific food or food group. Deciding whether to enact a policy excluding a specific food or food group is at the discretion of the LEA. In that way, the decision can be made based on the LEA's circumstances and student population. We caution that if you have implemented such an exclusion, bear in mind that such a policy may be viewed as a guarantee that some families will rely upon. Unless your school can ensure that all of your facilities are peanut-free 24 hours a day, and that there won't be an exposure when the students interact with different parts of the facility, such a policy may not be effective. Another concern is that having such a policy in place may lead individuals with a severe allergy to become relaxed about looking out for exposure to that allergen. As you can see, there are a number of things to consider before implementing an exclusion policy. We also want to mention that prior to this new guidance, schools may have considered and accommodated certain meal modification requests that were viewed as optional to make. It is possible now that under the ADA Amendments Act, those meal substitutions that were determined to be optional for the school to make at that time may now be required if the individual for whom the request was made is disabled. As stated earlier, a food allergy does not have to be life-threatening to be a disability. Similarly, food intolerances may be considered a disability if they substantially limit a major life activity. For example, if a child's digestion, which is a major bodily function, is impaired by gluten intolerance, their condition may be considered a disability regardless of whether or not consuming gluten causes severe distress. Let's touch on program accessibility. This is a whole other area of law and guidance, but we want to make sure that schools are aware that they must ensure that their food service areas are accessible to students with disabilities and that there is an independent obligation to provide auxiliary aids and services as needed for a child to benefit equally from the school meal programs. Some examples of auxiliary aids and services include food service aids, adaptive feeding equipment, meal tracking assistance, and other effective methods that facilitate equal access to the school meals programs for children with disabilities in your school or district. So we talked about what a reasonable modification is and how to arrive at that determination through interactive dialogue with parents or guardians. Now we will talk about where the modifications need to be provided. Section 504 specifically requires that students with disabilities be integrated in the school environment and be allowed to participate in the least restrictive environment. Meal modifications and meal service should occur in an integrated environment wherever possible. Exclusion of any child from the program environment simply as a matter of convenience for the school is not considered an appropriate or reasonable modification. We know that this can be tricky because when children with severe food allergies interact with other students who don't have food allergies, there is a potential for exposure. Prior to developing a special seating arrangement for a child with a severe food allergy, for example, the SFA should determine, with input from the child's family and medical provider, if this type of seating arrangement would truly be helpful for the child. If the school does develop a special seating arrangement, other children should be permitted to join the child with a food allergy, provided they do not bring any foods that would be harmful to that child. Schools should also keep in mind the stigma that may be attached to a student who is assigned a seat at a separate table or in another room. We want to discourage that where possible. However, if safety demands that the child be closely monitored or eat in a separate area from the cafeteria where the majority of the students eat, it is not appropriate to simultaneously use this area to segregate children who are being punished for misconduct. SFAs must obtain a written medical statement from a state-licensed healthcare professional in order to receive reimbursement for meals served to children with disabilities that do not meet SMP meal pattern requirements. In Pennsylvania, a licensed physician, certified registered nurse practitioner, physician's assistant, or dentist may write medical prescriptions and therefore may write the medical statements. SFAs do not need a written medical statement for modification requests that are within meal pattern requirements. For example, if a child has a common allergy to one fruit or vegetable, the school food service can simply substitute another fruit or vegetable in the reimbursable meal. Although SFAs will be reimbursed for a modified meal that is within the meal pattern, regardless of whether they have obtained a written medical statement, SFAs may choose to request a written medical statement in support of a request for a modification in all cases, if desired. This will help to safeguard children in all areas of the school environment and reduce misunderstandings and miscommunications. The updated USDA policy guidance tells us that the written medical statement must include information about the child's physical or mental impairment that is sufficient to allow the SFA to understand how it restricts the child's diet, an explanation of what must be done to accommodate the child, and the food or foods to be omitted and recommended alternatives if appropriate. PDE will be updating the medical plan of care form and instructions to align with USDA's guidance and will announce that update on pairs download forms in the Feeding Students with Disabilities and Special Dietary Needs section. Here is an example of what the medical statement should contain for a food allergy. The medical statement should identify the food to be avoided. It should provide a brief explanation of how exposure to the food affects the child. So, for example, it may say, Johnny should not consume eggs. And the brief explanation may be that, when consumed, eggs cause a severe rash and respiratory distress. The recommended substitutions must be provided. If for some reason the medical statement does not identify a recommended substitute, SFAs must reach out to the family to obtain that piece of information. Omission of a substitute or substitutes does not mean that the SFA is not required to honor the request. And we'll talk more about this on the next slide. If the modification request is not related to a food allergy, the three components of the medical statement are very similar. The medical statement should indicate the existence of a mental or physical impairment. It does not need to include a medical diagnosis. Second, it must explain how the impairment impacts the student's diet. And third, it must describe the modification that is needed or recommended. And again, if the modification is not specifically listed on the statement, schools should go back to the family and seek the information so that you can arrive at a modification decision. USDA guidance provides some additional information that schools need to know related to the written medical statement. The medical statement is no longer required to identify the specific disability or to use the terms disability or disabled. Schools may not request a diagnosis or medical charts. Instead, the medical statement only needs to include a description of the child's physical or mental impairment that is sufficient to allow the school to understand how it restricts the child's diet and to understand what modifications are needed to accommodate the child's impairment. SFA should not deny or delay a requested modification because a medical statement is unclear or does not provide recommended alternatives. If a medical statement does not fully explain the modification needed, the SFA should immediately contact the child's parent or guardian for guidance and ask the family to provide an amended medical statement as soon as possible. SFA should follow the portion of the medical statement that is clear and unambiguous to the greatest extent possible while obtaining additional information. Schools should not unduly delay a child's meal modification while waiting for the family to submit an updated medical statement. In this situation, school officials should follow up with the family if the school does not receive the requested medical statement as anticipated and maintain a record of this contact. School officials should diligently continue to follow up with the family until a medical statement is obtained or the request is rescinded. USDA does permit schools to claim a meal outside of the regular meal pattern for reimbursement while actively following up with the family and documenting the process. Medical statements are what provide the information that is most relevant to and important in accommodating special dietary need requests in the school meals program. When they are received, SFAs should not be engaged in questioning whether the stated medical or physical condition is severe enough to be a disability, and they should refrain from asking for other medical documentation, records, charts, etc. This is beyond what is needed to make the modification to come to a modification decision. Okay, let's address how to implement the guidance and the particular requirements that are highlighted in the guidance. First, a school should develop procedures for parents and guardians to request a reasonable modification. If a student needs a modification, his or her parents or guardians should know the procedures the school has in place, so that the modification can be requested and a prompt and equitable decision can be made on what modification will be implemented. Second, schools should train their staff and food service staff on the modification procedures in place, including the legal requirements in USDA's current guidance and what we have covered throughout this presentation. The ability to implement the requirements is, of course, contingent upon knowing what they are. Third, regulations require that LEAs employing 15 or more individuals designate at least one person to coordinate compliance with the disability requirements. This individual is often referred to as the Section 504 coordinator. This person does not need to be a new hire or someone who is exclusively dedicated to being a coordinator under Section 504. It may be someone who already deals with special education services in your school or district, or it may be an existing member of the staff who can have these duties in addition to his or her regular duties. In many cases, the 504 coordinator is responsible for addressing requests for accommodations in the school in general. So as part of their general responsibilities, this individual might also be the person responsible for ensuring compliance with disability requirements related to meal modifications and the meal service. Either way, there does need to be a person appointed and identified as a point of contact to ensure compliance with the regulations and current guidance. Regardless of whether the coordinator is a school food service employee, the coordinator must ensure school food service professionals understand the procedures for handling meal accommodation requests. The process of providing modified meals for children with disabilities should be as inclusive as possible. It is essential that SFAs work collaboratively with parents and guardians to ensure children receive a safe meal and have an equal opportunity to participate in the school meals program. The recommendation for a team approach has not changed. The most effective team will include school food service staff, school administrators, school medical personnel, parents or guardians, the child, if appropriate, depending on age, and other school officials with relevant experience, such as school nutritionists. Using a team approach ensures information is shared consistently throughout the school environment and will help to protect children in situations where food is served outside the cafeteria, such as during classroom parties. As I mentioned on the previous slide, LEAs are required to provide notice and information to parents and guardians regarding how to request a reasonable modification and their procedural rights. This procedural safeguard process is found in our program regulations at 7 CFR 15B. These are the same regulations that we referenced on slide 4, and as we told you earlier, the link is provided on PAIR's download forms for you to reference as you make your procedures meet requirements. LEAs are also required to notify the parents or guardians once a modification decision has been made. In the case that the parent or guardian does not agree with the modification decision, they must be made aware of their procedural rights. At a minimum, LEAs must notify parents or guardians on the process for filing a grievance or disputing the modification decision made by the school after review of the record. How to initiate the impartial hearing process to resolve grievances related to requests for modifications based on a disability, in which families and their legal counsel can participate. This is the typical IEP 504 process that most schools already have in place. Meal modification decisions are now under the umbrella of disability issues that are adjudicated in the impartial hearing process at the school. The procedure for the family to appeal any decision made during the hearing that they may not agree with. Before we move to your questions, we want to give you our contact information so that you can send questions that you might think of after today's presentation. As we said earlier, we will be compiling your questions into a Q&A document that will be posted on PAIR's this summer, in addition to an updated medical plan of care form.